This is Duke University.
Does it work? No? It's on. Okay. Okay. Come in, Sinan. Join us. Okay, hello everybody, and welcome to the annual international panel on comparative prosecutorial practice. My name is Nir Schneiderman, and I'm an SJD candidate here in Duke Law, and I'm originally from Israel. Before we start, I'd like to thank the dear members of the International Studies Office. I'd like to thank Dean Jennifer Maher. I'd like to thank Suzanne and Stephanie and Oleg, who's not here with us today, for doing such a great job in organizing this panel and encouraging us to take part of this panel and to participate. This year, the presentations will focus on the pressure employed on prosecutors. And by saying pressure, I mean external pressure, which is sometimes employed on prosecutors. And that means pressure from the whole public, pressure from politicians, pressure from other governmental officers. And I also mean internal pressure, which is the pressure that is employed on prosecutors by their supervisors. As most of you probably know, the US is the only country that still has the grand jury system. And that means that the prosecutor alone here in the US is not responsible for indicting people, but it's a decision made by a relatively big body called the grand jury. At the rest of the modern world, grand juries do not exist anymore. And in my country, Israel, and in other countries, it's the sole discretion of the prosecutor to decide whether to indict somebody or not. And that's a very crucial decision, and as most of you can think. And this is when the tense is mostly felt in our work as prosecutors. With no further delay, I'd be happy to present the three distinguished panelists. All of them, as you probably know, are LLM candidates currently in Duke Law. They are also pretty experienced prosecutors in their own countries. And I asked each one of them to tell us a little bit about the system of the country that he is coming from, and also to share with us a personal story about a case that he tried during the last few years. The first person I would like to present to you is Hiroyuki Sato. Hiroyuki is from Japan. He graduated in 2008 from the Waseda University School of Law, and then graduated from the specific legal training for prosecutors and judges in Japan. He then joined the Tokyo District Public Prosecutor's Office in 2009, was then transferred to the Yokohama District Public Prosecutor's Office in April 2011, and in April 2012, he was transferred to the Criminal Affairs Bureau in the Ministry of Justice and was responsible for legislative activities in that office and the execution of death penalties. So I'll take one step further away from you. Just a second, I just want to say a few more facts that are important. Hiroyuki is fluent in Chinese and Japanese. He plays basketball, and he recently became a father to a new American-born son whose name is Yuzuki. That's Hiroyuki. Our second panelist is Olga Bai, and here we're going to use some Israeli terms, so it's going to be much easier for me to present Or. Or graduated in 2006 from the University of California in Los Angeles, UCLA, where he studied political science, and then graduated in 2010 from the Interdisciplinary Center in Herzliya, which is in Israel. He worked as a private investigator in Israel between 1998 and 2000, and then for the Ministry of Justice in the Jerusalem District Attorney's Office. Now, I want to say one word about the Jerusalem District Attorney's Office. That's probably my biggest rival, because I'm from the Central District Attorney's Office in Israel. I'll try not to hold it against you during the panel, but you can certainly expect some tough questions at the end of the panel, so be prepared. Our third distinguished panelist is Do-yeon Kim. He's from South Korea. Do-yeon graduated from the Yonsei University School of Law in 2000, and then graduated again, earning an LLM degree from the same university in 2007. He passed the Korean exam in 2005, and I hear that it's a pretty tough thing to pass the Korean bar exam, and just a very small percentage of people actually manage to pass it, so good for you. He has worked in Mokpo District Prosecutor's Office from 2010 till today, and I don't have any fun fact about Do-yeon, but I'll say something interesting, that when we first started to prepare for this panel, and we set the first line on October 1st to send me the materials, Do-yeon was the only one that actually stood this deadline. So good for you once again. We'll move directly, with your permission, of course, to the presentations. Each presentation is supposed to take between 12 and 15 minutes, and that should save us about 10 minutes for questions and answers at the end.
Hello everyone, I'm Hiroki Sato from Japan, and I'm really honored to be here to introduce part of my job as a prosecutor. This presentation, title of this presentation gonna be Internal Pressure in Japanese Prosecutor Office, and I will mainly talk about internal approval system in Prosecutor's Office and the pressure caused from this system. First of all, I will show you how is the Japanese prosecutor office or prosecutor in Japan look like. And then second, I will talk about internal approval system, and then pressure caused from this approval system. Then I will give you one or two examples to illustrate how approval system or pressure works. Prosecutor in Japan. We are not country of Japan is not country of federalism, so we only have one single jurisdiction, and the prosecutor office are divided into this three levels. And bottom is district prosecutor office, and most of prosecutor, including me, belong to this office and deal with initial investigation, and court trial. And we are not elected, we are employed by mutual justice. And the interesting thing, one of the big difference from prosecutor in the United States is we are investigator, not just legal counselor or like barrister in UK. We are investigators such as police officer. So we interrogate all suspects, victims, and also witnesses who potentially testify in court trial. And sometimes we go to crime scene, and sometimes we attend search and seizure, and sometimes we attend autopsy of the body. And legally speaking, every single prosecutor can exercise the complete prosecutorial power. We have power to indict anyone. But unfortunately, we are Japanese, and have you ever heard that in business negotiation situation, Japanese businessman says, oh, I'm sorry, I have to ask for internal approval from my boss. This happened. By internal regulations, all prosecutors have to get approval from their boss, supervisors, regarding the, every action as a prosecutor. And this internal approval system is designed for keeping fair, equal, uniform prosecution in Japan, and checking the adequacy of the prosecution and educating young prosecutors through the approval process. I work for Tokyo District Prosecutor Office, so I will mainly talk about the Tokyo office. As you see, this is structure of the office. The prosecutors are assigned to specialized departments such as investigation department, trial department, special investigation department, like this. And all department has manager, not director, manager and deputy manager, and they will be supervisor to their younger subordinate prosecutors. Okay, I will show you how to get an approval. This is a really good question. This is typical scene of approval. This is not in prosecutor office, but it's look almost same. So you can imagine. Okay, when we ask for the approval, we get into the room of the supervisor and standing in front of the supervisor, alone, one-on-one, and with verbal communication, explain briefly, shortly, everything about the case. Facts, conclusion, evidence, legal issue, potential defense, and countermeasures. We have to explain our decision is correct. And your supervisor asks everything about the case. And he expects you to answer immediately and accurately. And important thing is, explanation, brief and to the point is highly evaluated. As you may see, this approval process is help for supervisors to evaluate their subordinates, younger prosecutors. Supervisors evaluate their subordinates through this approval system, and how the prosecutors deal with the cases or skill, knowledge, character. And this evaluation influence affects the transfer and promotion strongly. So, yeah, of course, we wanted to be preferred, liked by our supervisor. So it is really important to understand supervisor's preference or tendency. And we try to deal with the case appropriately, like it means fit into the preference of the supervisors. And this goes sometimes pressure. Okay. I will show you some type of supervisors I happen to see. One is really aggressive, asked to instruct or sometimes order to their younger prosecutor to indict a case. And on the contrary, there was one who are timid, reluctant to indict a case if there is no overwhelming evidence, really strong evidence. And it was a rare case, but worst one was always requires confession of suspects. Yeah, this is really problematic. This kind of type of supervisors sometimes push their young prosecutors into some inappropriate interrogation. But I won't know that this is kind of the characteristic supervisors, and most of the supervisors are experienced, really sophisticated and reasonable, and they lead young prosecutors to right directions through the approval system, approval process. Okay. Okay. Let's move on to example. This was. Where I dealt with this case when I was in Tokyo District Office Investigation Department. This was a case. This is a case of fight in bar between two drunken groups. Victim was a member of a group. And he was hit and injured on his head. The suspect was a member of the other group, and he was arrested shortly after this incident. Victim said to me he was hit at least 3 times by someone, but he was drunken and quite not sure what happened to him in the bar. And the suspect stated he was hit. He hit the victim once, but he said he didn't remember he hit the victim several times. There were 4 witnesses, and they stated the suspect hit the victim at least once. But their statements were different from, some of the statements were different from each other in that how the suspects beat the victims. And if you try to indict a case of battery, this is enough, but this is the case of injury, so you have to prove specific attack caused the specific injury. So I thought it was impossible to indict this case, and so I tried to get approval to drop the case. But deputy manager, my supervisor, says he don't want to allow to drop the case. He said he get angry and just saw the documents, evidence, pictures, and then said to me, "Investigation is not enough. Are you playing? And maybe you care for the objective evidence and investigate further." But actually, I couldn't understand what he said, and I felt pressure because I thought it was impossible to indict, but he said he forced me to do so. But after I reviewed evidence, I found something. I saw the picture of the victim and found the injury of the victim appeared on his head, but not only his head, they are on his face and back of the head and chin. So it indicated that at least 3 occasions he was beaten. And also the suspect, during the interrogation, I found the suspect was injured with his hand, both hands. So it indicated that he used both hands to beat the victim. And after I found this, I interrogated all witnesses again, and I found that they saw different situations. One saw one attack, the other saw the another attack. So it fit the injury of the victim. So finally, the suspect admitted. He said he remembered. And I indicted him, and he was fine. Okay, as you see, approval system and pressure sometimes problematic, but this have good effects on younger prosecutor or to educate a younger prosecutor. Okay, I will cut examples here. Running out of time. Okay, thank you for your patience and attention, and happy Halloween.
So Hiroyuki, next time you go to your boss, I think me and O, we can suggest some techniques to, to elicit contentions. Okay, our next speaker is going to be Olga Bai.
Thank you. Hi, thank you for the invitation and the opportunity, and thank you, Nir. My topic is going to be more concentrated on the pressure that the prosecutors in Israel have with dealing with the police. In the Israeli system, the prosecutor office is the one that decides all the legal issues, and the police are in charge of the investigation. And as you will see in real life, it's not so clear, and we work together very intensely. So let's start. So I work in the District of Jerusalem, and I chose this picture because this picture is a great representation of the complexity of Jerusalem. This is the heart of Jerusalem. Jerusalem is an old city, very narrow neighborhood, and very unique and distinguished communities that live close to each other. So you can see we have a lot of very holy places that are very dear and important to people, and they are very close to each other. And this is a good example because the neighborhoods that people live in are also very close to each other, and they are also, the people that live in there are very sensitive. And a lot of the time they view the police as representative of the government, as a foreign force that is not coming to help, and the relationship is not always so good. Another two important details about Israel, about Jerusalem and Jerusalem district. Jerusalem district is huge. It covers also the territories, and Jerusalem is the largest city in Israel and the poorest city in Israel. So imagine to yourself, you're talking about a huge city, according to the Israeli perspective, of course, with a very poor population, very religious, and very diverse. And you can imagine to yourself that this is a recipe for a lot of action. Yeah. So now I want to show you a little film right here. And let's see. Let's see if it's this one. This one, no, the other one. Right here, 1 second. Okay. I purposely put it without the sound. And this is, I chose a case in point, and I chose the group of the Orthodox religious Jews. And this is one of their main streets in Jerusalem, main area. This is called Mea Sha'arim. And you can see in the signs that are on the walls, it's written, you're not allowed to access the street without a modest dressing. So if somebody will get in there with not modest dressing, he could get spit at, he could get very awkward comments, and he can get sometimes beaten up. But the reason that I want you to see this clip is also to explain to you and to show you that there are real people that live there and with families, and they want to live their own life. And you can see that the streets are very narrow. And right beside this neighborhood, it could be an Arab neighborhood that just want to live their life. And a lot of the time, because of the proximity and the closeness, you have a lot of friction in those neighborhoods. So this is a little demonstration. And how do I return to the video? 1 second. Okay. And right here. Okay. So, as I told you, the tension between the police and the prosecutor, and soon I will get into it with more details, is about the decision to indict and the decision to ask for an arrest until the end of the trial. Because of, soon you're going to see another video, and because of the kind of conflict that we have in Jerusalem, it's very difficult sometimes to get an arrest. It's also very difficult to get some good evidence, and there is a lot of politics that are playing in this role. And I'm going to show you a video, and I want you to try to imagine yourself that you are one of the police officers that are in there, and you are trying to get evidence for court, and then I will say a few more words about it. So let's see this one right here. This time I will let you view it for a little while. So it's actually not in Jerusalem, but we have a lot of demonstration like this in Israel. And I love this. I don't love it, but I chose this. I chose this video because this is a perspective of somebody that is on the ground and is seeing actually what a police officer would have seen, or what a member that actually was part in this demonstration. You see, and I want to point your attention to the similarity in looking of the demonstrators. So how difficult it is to write. Try to imagine to yourself that you need to write on a paper this person that you don't know his name, with this hat, with this coat, did it. And he actually the one that threw the stone at me, and I saw it, and I had the eye contact from his hand with the stone that hit the police officer. And you can imagine yourself that these situations are not quiet at all, as you can see. And a lot of the time you have the police officers attacked, and there is a lot of emotions. When the police officers are in the area, sometimes they throw on them diapers, they spit on them, they beat them, and when they try to make the arrest, people jumping in and taking the people that they thought they had in the eyes. So this is where you can imagine the police really want to make some arrest. The police, and this is a good example of when we talk about law and we talk about reality. In reality, the police take it personally. It's not a scientific, it's not a lab, and they want you as a prosecutor to bring them results. This is a fight of who controls the streets. So I'm going to talk about one case that I dealt with. This was a few tax agents went into a neighborhood, the same neighborhood that you saw Mea Shearim, to make an arrest. And a few seconds, it's like a place where you have one rumor and it spread like a fire. Hundreds of people were running at them. They had to hide, call the police. The police came, and then all the population attacked the police in the same way that you just saw in the video. After a lot of hours, the police got some people arrested, and they really and they brought it to my table, and they brought all the pictures and the testimony, and I had to read it through and to go to court and ask the judge for whatever we decide, whatever I would decide. And I had a lot of problem because unfortunately for me, they arrested a very young boys. And this is another good example of seeing the transition from paper to court. Because sometimes when you read a case, you imagine to yourself, wow, I'm going to see these huge people that really beat the police officer, and then you see like three very young boys, and you say to yourself in your heart, you don't want to show it on your face, but you say, so how can I explain it to the judge that I want to ask an arrest? How can I explain the complexity of the situation in this specific demonstration that you just saw? How can I bring it alive when I have these three children with their parents, with three lawyers, and in court, and I'm standing by myself, and I need to explain that we have a problem, and the police have a problem. And if we are not going to bring some results, this city could not live in quiet, So, in addition to my troubles of having very young kids that are very short and slim, and very big police officers, huge police officers, standing in front of the judge, the defendant still go to school. This is an important issue for us when we make a decision. They didn't have any criminal record. The parents were willing to pay bail. And so another important issue regarding pressure, when I'm going to court, I got an SMS that the Ministry of Justice want me to report immediately what is the result of this case, because one of the people that got arrested was a son of a very famous rabbi. Okay? So the court was full of people, full of reporters, and I need to report if I succeeded or not. And then I'm sitting there with the lawyers, we're talking before the judge enters, and then suddenly the deputy chief of police of the old Jerusalem district get into the room and sit near me. and say, and whisper in my ear, if we are not getting this and this is shame, you know, and he's like, boom, you know, and I'm like, okay, I got this SMS, I got the deputy chief of the police, you know, it's very rare that this guy come, and he's actually a very infamous character in Jerusalem that even the police are afraid of him, you know, even the cops, and I'm saying to myself, and I have this case, you know, and eventually we got a compromise, and it's not thank you yet, I'm sorry. Eventually we got a compromise, like a lot of the time that we get in Jerusalem. And the compromise was that the kids would be in a house arrest outside of Jerusalem. They could still go to school, but in the evening they had to stay, they had to post a lot of bail. Everybody was happy, and eventually this case was closed in a plea bargain. However, the pressures that I felt in that day it's important to tell you that it's influenced you, but to a limit, because I was there alone. But I had my supervisor, and I could call, I could ask from the judge to get out of the court and call, and I actually did call when he came in. And my boss told me, listen, we deal with the evidence, because in this city, you have to be very strict. We are, actually everything we do will be in the newspaper in a day, and Nir can testify for that. It's very sensitive, and you have to be very clear that if you want to hold the city together, you have to be fair. And fair is compromise, and a lot of the compromises are not legal. It's not, the argument is not about the evidence sometimes, it's about what is sensible to do. And this is one of the experiences that I wanted to bring you, that we are studying a lot of the time the law and regulation, but in court, and with the judge and the lawyers, a lot of the time we talk about how we can make sense of the situation, how we can resolve it, and this is it. Thank you.
Thank you all. I think you forgot to mention the great experience of being a law enforcement person, standing in front of, you know, ultra-Orthodox Jewish people, and being hit by diapers, which are
I was on the other side also.
Full of waste, pretty dirty. That's a good experience. Anyway, we're gonna move on to our third and last panelist, and please welcome Do Yeon Kim.
Hello, I'm Do Yeon Kim from South Korea, and I think I don't have much time to do this, so I will go through as fast as I can. First, I would like to express my gratitude to the Duke International Studies Office for giving me this opportunity. Today, I would like to talk about traits and pressures of election crimes investigation in Korea. And before I starting this presentation, I want to make it sure that this is my personal opinion. And the Republic of Korea has a civil system. It has an independent and statutory election law, and the law imposes strict limitations on the election activities. Korea's political history, suffering from illegal election activities, urged the Congress to introduce this strict kind of regulation system. And I would like to talk about overview of election control system. Korea has a well-organized election control system, and mainly these three departments take charge of the control of the election. First, National Election Commission. This is the organization which takes charge of administration of election, and it doesn't perform investigation. And police officers investigate election crimes under the control of prosecutors, and prosecution service performs investigation and trials of election crimes, and it consists of prosecutors and detectives. Although the prosecution service belongs to the Ministry of Justice, the minister cannot give direction to an individual prosecutor regarding a specific case. So the independence of the prosecution service can be secured, and the prosecutors in Korea have a very firm and independent status. Now let's turn to the stages of election crime investigation. In general, police officers perform initial investigation under the control of the prosecutors. And in case of serious crimes, like higher-ranking public officers, prosecutors perform the whole process of investigation. Now, these are the major types of election crime in Korea: bribery for vote. This means direct bribery for vote, and first statement to the public, and illegal donation. The main topic will be the illegal donation. Illegal donation means if a person regarding election provides money or interest or expresses intention to provide the interest to others, that person will be punished. So usually donation here means the donation to voters, not from the voters. And let me explain a little bit about characters of illegal donation crime. Because the provision for illegal donation does not require a specific purpose or direct relationship between giving interest and voting, and just require the relevance with election, it has a really wide scope. And because of that, Korean election law provides various exceptions, but still, donation is very strictly regulated under the election law. And there are some difficulties about proving election crimes, especially illegal donation. Yeah, intention, it means mens rea. Suspects always deny intention and always deny recognition of illegality. And especially, it is sometimes disguised by the ratification of local Congress, because sometimes illegal donation has a form of administrative action. Even the local Congress sometimes ratify the donation. Now I will talk about some pressures regarding investigation. Some are from inside and some are from outside. When a prosecutor investigates the illegal donation of an official, especially, he or she must confront various types of pressures. First, there are some pressures from insiders. Usually, senior prosecutors who supervises over other prosecutors have conservative perspective about a case. Besides, Korean election law is being revised frequently and has no fixed official comments. So they are sometimes very hesitant about investigation of illegal donation, especially regarding an administrative action. Besides, if the prosecutor in charge fails, the prosecution service should deal with considerable criticism that the prosecution is too excessive or improper. And public opinions can be the pressure. Public opinions are sometimes manipulated by their involved politicians. Also, as the journalists are not ever favorable to prosecutors, it is almost impossible to reverse the unfavorable public opinion initially manipulated by the politician. And there is also some pressures from political party, because as the high-rank officials like governors in Korea can be a member of a political party, the party naturally concerns the investigation about them. The party sometimes uses journalism and sometimes holds demonstrations to place a direct pressure on the prosecutor. Now let me introduce a real case that I prosecuted in Korea, and it is the name of the case is the illegal donation of the governor of Sinan province. Yeah, Sinan is a small province and it is composed of 1,004 small beautiful islands. And if you look at the picture, yeah, I took the picture on my own, and you will see how beautiful it is. Yeah, and it is called Jaeundo, and it means the island of purple grace. When sunset, it goes purple like that. And although the size of the province is very small, it has abundant marine resources like fish, shells, and tourism sites, some sites for sports. So the size of the official budget of this province is quite big. Its annual expenditure budget is about $400 billion, and there are just 45,000 people in that province. So many politicians want to be the governor of it. And yeah, from November 2009 to April 2010, it's the right 2 months before the election, the governor gave about $700 and $70,000 to a Marine veteran organization. It's about $40,000 for office facility and $30,000 for cars. I performed almost a whole investigation and acquired official budgets and reports regarding the expenditure. When I interrogated the governor, he claimed that he had no intention to make a donation to affect the election. And he urged that he didn't know it was illegal because the budget item he used was specified as the fund for Commonwealth of Residents and ratified by the local Congress. He urged that expenditure can be regarded as the normal subsidization for Commonwealth of Residents. However, after I interrogating local officials who actually executed the expenditure and reviewing some budgets and official papers, I found that the specification of item, the fund for Commonwealth of Residents, was exceptionally abstract comparing with others. And the item had been actually used for any reasons for several years. The local government officials call it as just pocket money or full budget. Besides, according to the witness, who was the chief of the veteran organization, the witness promised to help governor regarding upcoming election for the price of the expenditure. In addition, I found the governor's handwritten memo, which showed that he directed subordinate officials to use that budget item. Actually, there was another specified regular budget item to subsidize civil organizations, but in order to use that another regular budget, there should be reviewing process that can last almost several months. So the governor decided to use this kind of budget. With these evidences, I could prove his criminal intention that he tried to use official budget for the election, and his criminal conduct that he ordered subordinate officials to use full budget for the illegal donation. Actually, this case itself is not that big. At last, he found guilty by the court and sentenced by the fine of just about $700. Yeah, I know $700 is not that big money at all, but according to Korean election law, if a defendant who has the position of governmental official is convicted over about $900, the defendant will be forfeited for his or her position automatically. So it's not just about $700, it's about $400 million position. Originally, he was sentenced enough to be forfeited of his position at first trial, but the appellate court diminished the sentence with ambiguous reasoning. So this case made a lot of controversies. Also, the real value of this case is that the tricky official budget expenditure can be punished for an illegal donation of election law. At the time of investigation and trial, I had been suffered from continuous demonstration in front of my office building and had to persuade my senior prosecutors to cope with Supreme Prosecutor's Office's negative opinion. Even the seniors in the Supreme Prosecutor's Office were hesitant to indict the governor. Besides, journalism paid much attention to the case and public opinion was not that advantageous. However, I thought unless the action in issue is punished, the present governors who were very influential to local Congress could manipulate the special budget and he would be able to use official budget for their own regarding election. So I think it was too unfair to rookie politicians, and it could severely damage the fairness of the election. So I persuaded my supervisor with found evidence and some knowledge of administrative action and official budget principle. And I had to deal with opinions of the public or demonstrator with the firm notion of impartiality. According to my experience, to know legal knowledge and to apply the knowledge into the real cases are very different. To apply the knowledge properly, we should cope with various types of pressures. As for me, I had prosecutors, 3 governors out of 4 governors and 1 mayor in my jurisdiction, and 2 chief members of local Congress, along with several politicians. None of them was easy. It's not because I didn't know some principles or legal knowledge regarding case. It's because I must keep my conscience toward cases. So, indeed, coping with various pressures with integrity is the key to my purpose. Thank you.
Okay, we have about 10 or 15 minutes for questions and answers, so feel free to go ahead and ask questions.
I think I paid somebody to ask a question.
Okay, yes, ma'am.
This is a question for all of you. Do you think it's a more efficient system to have separation between the prosecutor's office and the police in terms of investigative function? Or do you think that the combined, as it is in Japan, where you have a combined role of investigation and results in more, I guess, more prosecutions and more convictions?
I'm sorry, say that please. I couldn't hear clearly. I'm sorry.
So do you think it's a better system to have one office that does both the prosecuting and the investigating, or do you think it's more efficient to have a separation where perhaps the police does the investigation and then the prosecutors does the actual prosecuting and making the decision as to whether to prosecute?
I think our system is better because not because I'm a Japanese prosecutor, but because we indict the case and we do court trial. We are in the courtroom and do prove the incident. So we have to gather the required necessary evidence. But police officers are not attorney, legally educated. So we as lawyers have to control or sometimes investigate by ourselves. So I think this is better system.
I will give the other side of the equation. I think the fact that we are not involved in the investigation, it makes us a little bit less biased. Because when you are making so much effort and hours of looking at documents and trying to actually think about the set of mind of an investigator, and as Nir said, I also work on the other side, you really want some time, you really think that you know it. And we give it fresh eyes. We look at the case cold, we are not emotional about it, we were not in the scenes, our friends were not there, and we provide a fresh light, and sometimes we also instruct the police to go and do additional investigation. But I think it's a good cold-in effect to the investigation that we can look at it again, and we can have a decision that did not infect our work, because we didn't invest hours just like spending interrogating evidence, and so I think I like our system. Yeah.
And if I may add something to what Or just said, I'll just try to sort of find the third end of that equation. You were also mentioning, I think, financial considerations, and this is something which is really important. So in Israel, and I think Or mentioned at the beginning, if we're talking about a severe crime case, then I mean, it would usually be investigated by the police, and then the case would be transferred to the prosecutor, and the prosecutor will reach a decision whether to indict or not. But if it's a misdemeanor, for example, or if it's a light felony, and we have this distinction between, severe felonies and light felonies, in that case, then the case would remain within the police hands, and the police would not just investigate the case, but will also decide whether to indict that person or not. As Or said, it's a little bit problematic because the people who investigated are the people that's supposed to decide whether to indict or not, and usually, as Or also said, the pressure on the policemen is much higher and much tougher because they are right there, in this specific fracture, living with the people at the field. But on the other hand, think about this scenario that somebody has already read the case, studied the evidence, and that person is a lawyer. He's not a prosecutor, he's a policeman, but he's also a lawyer. Why should somebody else now study the case from the beginning and reach the decision whether to indict or not? So that's the other side of the equation, but I think there's no clear-cut answer for this. But that's a good question. Thank you. Anyone else?
Yeah.
Yes.
Actually, I have a few questions for my friend.
I'm happy.
Okay.
Because really it's a good opportunity to meet you and to make some issues clear to me. I didn't understand it before.
Okay, but don't ask a question that he told you to ask. Ask something else.
The other one.
There's West Bank under occupation, Israel, there's prosecution system, military prosecution system, and West Bank in special military court. My question is it the same system for Israel? Is it the same system?
It's not.
For example, are you able, because you are practicing in Jerusalem, are you able to practice in the military courts in Salem or Haifa or this?
Right.
This first question. Second question, you mentioned something about compromise. Actually, I don't understand it very well. And I heard my colleagues, lawyers who practice in the military courts, they said, okay, we reached a compromise with the prosecution. My question is, how far the judge will accept this?
Okay.
Does he have authority to revoke it or?
I have.
I have another question.
Let's answer this question first, and then we'll have time for the other.
Let's cut them a little bit. And the first question, I will, if you don't mind, I will answer the second question, and I would let Nir answer the first question because he was actually working in the army a little bit more than me. And with regard to the second question, I want to use my friend Kim's statement that this is only my opinion. Okay, because it is extremely, especially in Jerusalem, there is, and you have to be there in order to feel it, to sense the political pressure in court. And when I'm talking about in court, I'm talking about in the corridors of the court. Most of our conversation and most of our bargaining and agreement and compromise are done in the corridors. We're actually standing, drinking coffee, very friendly relationships, outside of court, and we are talking. And the judges in Israel love it. They love it because they have to work less. The more we compromise, the more, and this is, I'm telling you 100%, everybody in court, and this will surprise you, and I'm sure it's not only in Israel, everybody in the court system want to go home in the end of the day to his business. The police officers, the guards of the court, the judge, the secretary, the lawyers, and believe it or not, even the defendant. We want to reach in Israel. We are aiming at compromises because the situation and the factual situation is so difficult sometimes, and it's so contentious that we have to get because if we push the wall, if we push the envelope all the time, we cannot live together. So this is a city of compromise, and even though it doesn't seem like it in the news a lot of the time, in reality, in the coffee shop of the courthouse, you really see the coexistence in Israel, and you really see the friendship and the life. This is my answer for the second one.
Okay, so military court doesn't have a coffee shop. But on the other hand, it doesn't look like Guantanamo, like the Guantanamo military commissions, for example. From one hand, that's an open trial in a military court in the West Bank. So you mentioned, just that the people will get a sense of understanding what are we talking about. You mentioned Ofer, you mentioned Salem. I will add Erez by the border, the previous military court by the border of the Gaza Strip, which are, courts that during most of the sessions, the trial is open for the public, and people can go and attend the trial and take a look and see exactly what happens there. I won't say that the procedures are exactly the same as the procedures in courts in Jerusalem or in Tel Aviv. The procedures are a little bit different, but it's mainly because the main law that controls the West Bank is the Jordanian law. And this is something that if we want to follow the international law, we cannot just establish Israeli law there. It would be illegal. So we have to follow the Jordanian law, because the Jordanians were the ones to control the West Bank until 1967. So it's a little bit different, but the process is open for everybody. On the other hand, we have a problem of suspects that do not trust their own lawyers, by the way, which is also a little bit problematic. So if you can't attend a session in Guantanamo Bay, but it would be interesting to see that the defendants are represented mostly by military personnel, by US military personnel. This is something that does not happen in Israel. Okay, so a defendant in a military court in the West Bank will not be defended by an Israeli officer. He'll be defended by it's either Muslim or Christian Arab attorney. But it's pretty easy, and I'm sure, I don't know if your friends told you so, but it's pretty easy to get a certification and to represent people in military courts. And I'm sure that people will tell you that they get a vast amount of time, a huge amount of time to present the legal arguments in military courts. I can tell you that if it's a severe case where a lifetime in prison or even the death penalty is sort of on the desk, according to Jordanian law, the court must look into the evidence even if the defendant admits. So this is something that you will not find in Israeli court. I don't know, I think it's more or less the same in other countries in the Far East, but I don't want to talk about that because I'm not sure. But this is something pretty unique. Think about it. The defendant admits, and the court must look at the evidence and make sure that there is enough evidence to convict this person in such a severe crime. So it's not perfect. It's far away from being perfect. But we're trying to, we adhere to the international law, and we're trying to make it as close as possible to other courts within the 67 boundaries. That's a good question.
Okay. What about, you mentioned about Jerusalem, because Jerusalem has a very sensitive situation, and I know how much sensitive work you have. There's Arab population there, and some of Arab Palestinians living there, maybe they are involved in activities, political activities.
Right.
Would those people be sued in the military prosecution, or in Jerusalem by
Right. I had a lot of cases like this. So apparently they are prosecuted also in Jerusalem, and it depends, I guess, where the offense is being committed, right? So I was debating, to be honest with you, I was debating about telling a different story, and I chose in purpose as a group, a case in point, the religious Orthodox group. However, in reality, the most amount of problems and prosecutions that we have is against our citizens or not citizens that are resident in Jerusalem. And this actually creates a lot of difficulties. And in 12 minutes lecture that I prepare, I thought it will be too little to get into these difficulties, because there is, like Nir mentioned, a lot of question of trust. And I would just throw it here. There is a lot of risk. People that testify in my cases can lose their life like this, or their family, if they are suspected of cooperating in Israel. I need to be extremely sensitive if I bring the case or not. And this is why I have really great supervisors, and we are extremely sensitive. By the way, another case that you never think about, let's say that the woman got raped, and she is from a family, that if the family know that she got raped, they will kill her. What do we do? This is my decision. It's sitting on my table, not alone. Not alone. But this is my responsibility. Because if tomorrow she gets killed, because I decided to provide what we call justice, I have to deal with this. And this is some of the issues that we need to deal in Jerusalem. And this is a great example of how law school become a complete different reality in court, in the Jerusalem district.
Yeah, and if I, again, may add something to this, you would probably find it really interesting to know that most of the prosecutors, again, in the West Bank, in the military courts, are civilians. And what do I mean by say civilians? I mean, they go and they practice their reserve duty 30 days a year, or something like that. Other than that, they work in banks, they work as corporate lawyers. Some of them work as prosecutors, just like I am, in the civilian system. But, they come and serve for 30 days as a prosecutor, sometimes even as judges in military courts in the West Bank. Now, that brings a very unique perspective, because as a reserve officer, you should, of course, always follow the ordinance, that's for sure. But you're much more flexible. Okay, your career does not depend on a specific case, on a specific decision. And even though you are affiliated with a specific system which has its own agenda, you bring some of your own. And I can tell you from those who know me, but I can tell you from personal stories about other people, that people bring really interesting agendas to military courts. And people are people at the end of the day. And it's a court. It's an objective court managed by people who are civilians most of the time, most of their lives, and who try to have fair trials. And if you read the Amnesty report, for example, they are not compared to any other military courts in the world in terms of fairness. And again, it's not a perfect system. Okay, I think that if we have no further questions, so please join me by thanking our distinguished panelists.
Produced by Duke University. Online at duke.edu.